So, my lady, we were at page 213 of the Authorities Bundle, looking at Article 13, we're about to look at Article 13 of the Withdrawal Agreement. And the first point to note is that the structure of Article 13(1) through to 3 is basically the same. And my learned friend sensibly conceded that nothing turned upon the ordering as to when words rights or limitations or conditions, etc., appeared in the text of these particular articles. It mirrored a debate we had below before the Upper Tribunal, which culminated in my learned friend Miss Smythe conceding that you had to look at effectively the object of all three of these provisions, which are directed at the same target, and points about ordering therefore fell away. And my learned friend effectively fairly said that his case was, nevertheless, that the relevant right was the right in the article at all, and that there were no references to these provisions for the purposes of the rights they contain, merely the limitations and conditions referred to in the text. And he then supplemented that by reference to an argument, which I'll come back to the effect that Article 21, shorn of citizenship and shorn of free movement, makes no sense at all. But the thing I'd like you to ask you to note presently, that with the exception of the Teixeira right, which appear later in the scheme of this part, and of the constitutive Article 3.2 wider family member rights, this is the complete inventory of EU residence rights available under the corpus of EU law, with one important category exception. And the important category exception you won't find here, but in fact flows from the terms of Article 10. It is those rights predicated on what you might call reverse discrimination. It's the Zambrano rights and the Surinder Singh rights. And the reason that they are excised is because you can't get through the gateway in Article 10 with a Surinder Singh or Zambrano right, because you won't meet the condition of being a Union citizen in the UK or a UK citizen in the EU. They necessarily entail rights asserted by a UK national against the UK itself. But for those categories of right, everything in EU free movement law, if you pick up Peers on Free Movement or Barnard or one of the standard books, everything you see there appears in this list. And that's what it's intended to do in our submission. The sorts of distinctions my learned friend attempts are far-fetched. It's basically taking all the Lego blocks, bar the red ones for reverse discrimination, and saying those rights shall continue, subject to the bells and whistles that are provided for in the rest of the part. And part of the bells and whistles are the special provisions in Part 18 about changing those rights into a constituted document through the PSS process. Now, there is a complete set of rights. You can see if you scan on to Article 24.2, I'll come back to Article 13 in a second. Article 24 is directed at ensuring that the consequential rights of workers are provided for. My learned friend attempted to make something out of the word of the rights plural here, and there were some questions about this. This article has a very different focus. It's directed not at the rights of residents, but at the consequential rights to work once you've been admitted into the territory in question. And there is a dedicated regulation, Regulation 492/2011. My Lord Justice Green probably remembers Regulation 1612/68, which was the predecessor to this. And it adumbrates all the rights that workers have in their host state, and its rights like equal pay, access to social assistance, etc. And those lists are non-exhaustively codified in Article 24.1a through to h. I could give you an example of a right that doesn't appear there, the Bosman right that founds your entitlement to attack the eligibility rules of sports organisations, isn't there. It's nevertheless ported over by the scheme of this. And then, as an adjunct to all of these rights, the regulation and its predecessor, 1612/68, I think it was Article 10 of that, provides for an express right of residence for a worker in situations where their child has, after they enter into the country and work there, their child has entered education. In other words, if you become sufficiently integrated in a state that your child enters the education system, you have a right to reside until that education finishes at least the secondary education level. And that's why the last and only remaining right of residence appears here.
You've now AT's right contingent upon her child's education occurred after the decision, so the hypothesis that we're looking at predates that. I mean, that may be relevant to her position personally now.
Yes.
It wasn't the case on the facts when it was before the decision maker or the tribunal.
Of course, and all I'm pointing to this to show is that the reality of Part 2 of the withdrawal agreement is it's a complete list of rights identifiable from the corpus of EU law, all of which are being preserved essentially on their own terms. And my learned friend's attempt to separate the rights from their obligations is a completely artificial exercise. And in relation to Article 21, it's a particularly meaningless exercise, because if you look at the text of Article 21, the only limitations it contains are that the exercise of the right to move and reside is subject to all of the limitations provided in the treaties, which is the limitations provided in all the other articles already listed in the text of Article 13. So it's, on his analysis, total surplusage. If it's just conditions, it's only if it confers a right of residence that it has any meaning. And of course, we know from CG that it does confer a right. Now, there's one other point to note about Article 13, and that's the text of Article 13.4, which Mr. Justice Lane looked at in the IMA case. It says, the host state may not impose any limitations or conditions for obtaining, retaining, or losing residence on the persons referred to in paragraphs 1, 2 and 3, other than that provided for in this title. There shall be no discretion in applying the limitations and conditions provided for in this title other than in favour of the persons concerned. Now, that section is very important because it answers this basic question. It's a topic I'll come back to. Why doesn't the Secretary of State proceed for ILR under the EU settlement scheme in the way that the Secretary of State proceeds for third country nationals? In other words, by setting some form of no recourse to public funding condition unless you're in work or self-employment or economic self-sufficiency. And the answer is to insert any NRPF condition into the residence right here would conflict with the requirements of Article 13.4. And that, in my submission, is the genesis for the technique in fact used, which is disability through eligibility in the eligibility regulations. And that explains why the limited leave to remain, I think I said ILR, the limited leave to remain technique of the NRPF condition is unusable in this context. But it also thereby tells you something about the substance of the effect of the updating regulations, which is what we're talking about at the end of the day. Their substance is functionally akin to an NRPF condition, and the decision as to whether or not to waive an NRPF condition is functionally akin to the decision taken pursuant to the CG dignity override. In other words, a discretionary consideration of the facts and circumstances of an individual case to see whether or not dignity or their straitened circumstances requires an exception to be made for them. And that's, I think, relevant to some of the criticisms made of the reasoning of the Upper Tribunal. So that's Article 13.4. It's helpful to note Article 17 that provides in terms that once you're in with one of the rights, a change in your status doesn't alter anything. So if you move between being a student, a worker or a self-employed person, that doesn't affect your rights under this part or the application of the part. And then you have Article 18, which is the procedure for effectively obtaining settled status or pre-settled status by means of a constitutive process if the relevant host state so elects. The UK has, I think the member states are kind of split 50-50 between them. Then you've got Articles 20 to 21, which replicate the provisions of the CRD dealing with public security, public order, expulsion, etc. The Bouchereau line of case law is codified in the CRD. And then at 23, you have the equal treatment obligation. And you have my point that though this is superficially very similar to the CRD Article 24, its scope is actually far wider because it bites upon all of the part rather than all rights of residence simply in the CRD. So the CRD is confined to rights of residence under the CRD, and the derogation is differently expressed. Whether that has any significance is a matter for another day. That is the basic scheme of the withdrawal agreement. And it is one in my submission that is absolutely clear as to how it's intended. It takes the building blocks, it requires them to be interpreted in line with Article 4.1 and 4.3 as they were before, applying standard EU techniques, and the logical consequence of that whole exercise is continuity. That's my topic 2. Topic 3, some preliminary remarks about some of the things that my learned friend said. The first thing is what he said at paragraph 4 of his skeleton to suggest that my client lacked lawful residence under the withdrawal agreement. That is a strange submission to be making in circumstances where the Secretary of State has said nothing whatsoever about how it is that AT actually falls within the material scope of the regulation or the withdrawal agreement in terms of Article 9. And it was accepted. I think this is the full extent of the Secretary of State's concession. It was accepted that as at the end of December 2020, AT was still in the throes of the 3-month period provided for as of right under Article 6 of the CRD, and she was therefore in scope for that reason. But if that's the case and she's in scope, it's very difficult to see what the substance is of the submission, that she's not a circumstance of lawful residence under the withdrawal agreement. Now, you'll appreciate that...
So when she first came to the UK, which I think was in 2016, and then secondly in 2018, on those occasions, which were before the Withdrawal Act came into effect, she was exercising ordinary free movement rights.
Absolutely.
Then she stayed on under the withdrawal agreement.
Yes. And she actually remained a worker under the Sun-Pre doctrine for the period of her maternity leave until that end.
I was trying to track that into the various ways in which the court formulated CG's right of residence. I mean, there's about 5 or 6 paragraphs where they describe why she fell under Article 21. It's effectively because she was exercising her free movement right under Article 21 at and during the transitional period.
Yes, in her case it seems, and that's why I drew the attention to the facts I did at the beginning, in her case it seems to have been a bare exercise of free movement, and she seems to have been...
Well, they say, I think they say that in about 7 different paragraphs.
Yeah, it's much closer to the old category of what was called the lawfully present. And the lawfully present were people who were EEA nationals, who by dint of their EEA nationality weren't subject to immigration control. They had the automatic right to enter the country for 3 months. And thereafter, the state, in practical terms, took no interest in whether they remained in the state or not, save that it said, and this builds upon my learned friend's submissions about how the law changed from 2004 onwards. From 2004 onwards, the law of social security was configured to ensure that the lawfully present did not receive social security. That was the only response to the presence of the lawfully present. And there's a case called Abderrahman in the bundle that documents all of this. Now, what is significant is the nature of the right granted under the EU settlement scheme, and in particular, limited leave to remain. Because in terms of the Immigration Act, the limited leave to remain you obtain under the EU appendix is identical to that obtained by a third country national. The only difference, ultimately, is one of practice, which is that third country nationals routinely have NRPF conditions inserted into their limited leave to remain, whereas EU nationals do not. And that means that the controlling mechanism for access to benefits in the case of a third country national is the risk that if they apply for benefit, they will lose their limited leave to remain and be vulnerable to deportation in consequence. Therefore, is a very direct threat to their continued residence in the jurisdiction, and that's why there's the whole NRPF waiver system. By contrast, as was detailed at extensive length in the Fertilla litigation, the bar for these claimants is a regulation that says this type of residence doesn't qualify you for the benefits in question. And that's relevant to understand the proximity of the whole NRPF system. The second point my learned friend made, and it does require some engagement, it's a point I think more developed in his written submissions than he developed orally, is about the supposed generosity or overwhip of the EU settlement scheme compared to the strict requirements of the withdrawal agreement. Orally, he referred to it, without developing the point, as some form of gold plating that you should be aware of. His written submissions go a good deal further and tend to suggest a kind of suggestion that in relation to areas of generosity not required by EU law, or the withdrawal agreement might not run at all. Shades of the arguments Mr. Coppell and I had in front of my Lord Justice Green in the Hughes litigation. And that argument hasn't been developed, but I do invite caution for this reason, because sitting behind the widely formulated grant of rights to those who are economically inactive are certain cohorts of people who may well have assertable EU rights who simply haven't asserted them. And there are two categories. There are the family member candidates under Article 3.2, and there are the economically inactive members of durable family relationships. Now, the first category is easily explicable in these terms. You can, if you want, regularise your position as a member of a durable relationship by invoking Article 3.2 and Regulation 8 of the 2016 regulations that I've provided. But many people couldn't be bothered to do that. They didn't need to, because they could come into the country, they'd be lawfully present, and unless they needed access to the social security system, it made not the blindest bit of difference to their lives, particularly if many benefits are in any event awarded by reference to the fact of parenthood. The worker, durable partner may be working, gets the benefits that way, or the fact of a couple cohabiting together without any inquiry as to their residence rights. And so there may be, and is, I would suggest, a suppressed category of those who would be entitled under Article 3.2 to have their durable relationship recognised if they'd ever bothered to do so. Now, the withdrawal of the UK from the EU would have, but for the EU settlement scheme, prompted a deluge of applications from people properly advised under Article 3.2. And they would have triggered, if they had succeeded in time, a right of residence under Article 10.2 that I showed you earlier. And that if the application was outstanding, they'd be ported over under Article 10.3, as I showed you. But because of the generosity of the UK scheme, as it's called, there was no need to do that. You could simply apply under the form, and if you could show presence and the limited evidence you had to supply under the EU settlement scheme, you got the right of residence you required in any event. And it's exactly the same analysis with respect for the economically inactive who are self-sufficient, a category into which my client may well, I put it no higher than that, have fallen had there been any need for any such inquiry in December 2020, when she was still in a partnership with V, cohabiting with him providing for the needs of their daughter and their family unit. There will be many who are victims of domestic violence who will fall into that trap, an expected stable relationship, providing for you, in effect, being economically independent via your partner, collapsing and you transitioning from economic independence into financial desperation. And it's for that reason I suggest you should take with a very large pinch of salt the idea that simply because the approach adopted as a matter of convenience and in order to save other investigations or other inquiries is a broad approach to economic inactivity, that the result somehow is unwarranted generosity to either my client or many like her. With respect, we don't think that follows at all. The truth is that this was a decision on the political plane to keep matters simple, to provide certainty, and to provide reassurance to those who had established themselves in this country that they would continue to be so entitled. And having made that decision, the Secretary of State has to accept the consequences of that decision as identified in the CG litigation. And that brings me on to CG. I should scrap my topic 4. I should scotch at the outset the idea that CG is some form of perplexing development in the law. It's anything but. It's a standard piece of case law reasoning by reference to different facts and circumstances and careful distinguishing of previous authority. The court was asked, effectively, how the Troiani and Dano Alamanovich separate strands of case law were to be reconciled, an issue it had never grappled with beforehand. It decided that Dano trumped Troiani in terms of equal treatment, but that there was, nevertheless, consequences of possessing domestic and therefore lawful residence under Article 21. It's not perplexing, it's not difficult to understand, it's entirely principled. And there's more than a whiff of sour grapes or le beurre et l'argent pour le beurre about the government taking the benefit of the ruling, knocking out the Fratilla case, and then complaining about the proviso that rides with it. But there we have it. Now, the most helpful place to start in the parsing of the judgment is the Advocate General opinion, Advocate General de la Tour, Authority Bundle 2, tab 59, page 1656. He flags his headline conclusion at paragraph 5 of his opinion. And his headline conclusion, I think again is the conclusion reached by my Lord Justice Dingemans, is that this is a case of indirect discrimination, not direct discrimination. And that was a conclusion with which the court disagreed. As it transpired, the court concluded it wasn't any kind of case of discrimination, indirect or direct. But his subsidiary conclusion was that in any event, and by way of principal departure from Dano and Alamanovich, the case law required the application of the Charter to those cases of lawful residence founded upon a domestic right of residence. And based upon that, he described type of process of individual inquiry that would be required in order to discharge that duty. And the starting point for analysis in that respect is, first of all, and I'll just give these for your notes, so I won't take you through them, paragraphs 35, 44, 54 to 55, and then culminating at 61, which is the passage in which he explains the issue is whether or not Troiani is good law, and the conclusion at 61, page 1668.
So what was your reference after 35, 54, 55, 61?
35, 44,
Thank you.
54 to 55, and then 61. And the consequence is that a union citizen who is lawfully resident on the territory of a member state, although he or she does not have means of subsistence, may be treated differently from the nationals of the state on the sole ground that the host state has granted him or her a right of residence without conditions as to resources. In other words, it was a relevant differentiating factor entitling discrimination subject to the control of indirect discrimination. The balance of the analysis then, and critical to this is critical to the indirect discrimination analysis that follows, is the passage at 75, where he explores the concept of legal residence. And the reason why legal residence is relevant is because legal residence is relevant to the scope and application of Article 21. And at 81, page 1671, as part and parcel of his conclusions as to why legal residence is nevertheless residence within Article 21, triggering indirect discrimination analysis, he says, effectively, the fact that by granting a right of residence to the union citizen puts them in a more favourable condition than those laid down in the directive, still means that the member state is implementing EU law for the purposes of Article 51(1) of the Charter. And here's the crux. In that regard, I'm of the view that the scope of the court's decision in the judgment in Dano concerning the possibilities of relying on Articles 1 and 20 of the Charter is limited, since it relates to the conditions for the grant of special non-contributory cash benefits in the context of a person not having a legal right of residence. There's the critical distinction. That distinction is then built upon in his human rights analysis that starts at paragraph 102, in fact at the end of his indirect discrimination analysis, because having set out how he thinks the indiscrimination analysis should work, he says at 102, you'll have to supplement that examination will necessarily have to be carried out by reference to other fundamental rights applicable to the individual situation at issue, provided that it falls within the scope of the directive, see point 81 above. In other words, he's saying there's this general analysis to be done, and what's more, it's going to be fortified by human rights analysis where that applies. And then 103 and following explains what it is that he says is required by way of justification. And it's notable at 104, he sets out how important the facts are, which he looks at. And he says at 105, those facts, to my mind, allow a comparison to be made with the decision taken in Chavez-Vilches, although that case had as its subject matter the rights of residents of third country nationals in the member states of which their children were nationals. And he says that's for three reasons. First of all, those are all situations governed by legislation which falls a priori within the competence of member states. Next, they, however, have an intrinsic relationship with free movement and residence of the union citizen. We would entirely agree with that. Last, the request for the interpretation of Article 20 referred to by the court was justified by the fact that it could not be excluded that the parent who was also a national of the same host member state might be able to take charge of the primary day-to-day care of the child. And what that's inelegantly saying is that in Chavez-Vilches, the key issue was this. There was a third country national who was the parent with care. They were all mothers, as is ever the way. And there were EEA nationals, Dutch nationals in Dutch, who were the father, who weren't the parents with care, and the children all had Dutch nationality. So it was a Zambrano type case, but where one of the parents had an EEA nationality and one did not. Zambrano, both the parents were third country nationals. And the argument that the Dutch were advancing was, well, although the mother is the carer, you can nevertheless expect the child to remain in the Netherlands when the mother is sent back to whichever third country they come from. That wasn't in fact going to happen, but the question was whether or not they had a derived right of residence and the proxy that might otherwise occur. You can expect the father to care for the child. And the response of the CJEU was one in which they, first of all, said that the rights of the child were the primary consideration. And if you take up the case I handed up, you can see that in the Advocate General's opinion. The Advocate General's opinion at 42 through to 47, and this is probably the most recent and clearest articulation of where the interest of the child sits in the EU legal order. And I ask you to note in particular 43, where he says the court has already had occasion to point out that the Convention on the Rights of the Child binds each of the member states as one of the international instruments for the protection of human rights, which it takes into account in applying general principles of EU law. In other words, it is a general principle of EU law. The fact that everyone's a signatory to it shows it's passed the common constitutional conditions. And then what's more, that conclusion is bolstered by the enshrinement in the Charter over the page, Article 24, etc. That's the first point. What was required, according to the Advocate General, was then an individual assessment of the facts of each case to see effectively whether or not it was in the interest of the child that the father should take care of the child, whether the father was able to do so, etc. And he was emphatic, as was the court, that that was a conclusion that depended upon the facts of each particular case, depending on the nature of the father, the nature of the relationship to the child, etc., etc. And you see exactly that reasoning condensed in the court's analysis at page 145, paragraphs 70 to 71. 70 restates the primacy of the best interests of the child, and 71 is a clear, unambiguous indication that in order to reach a judgment on this issue, account must be taken in the best interest of the child concerned of all the specific circumstances, including the age of the child's physical and emotional development, the extent of his emotional ties both to the union citizen parent and to the third country national parent, and the risk which separation might entail. Now, it was that analysis to which Advocate General de la Tour was effectively drawing upon by analogy at 108. If we go back to that.
Can I just ask, before you do that, this looks more like a court-based analysis in 70 and 71 than a social security one.
Yes, because the underlying issue was in fact one for the relevant Dutch Social Security Court, which was to decide whether or not there was a Zambrano-style derived right of residence for the mother. And that could only be assessed by looking at all the relevant facts and matters in question. It was a social security dispute. There was no suggestion that the mothers in question were going to be excluded. They were saying, we have a right of residence, and that under the Dutch test was going to be enough to gateway entitlement. Whereas, of course, in our system, Zambrano rights, if my Lord Justice Dingemans will recall, were the other category of rights excluded by the relevant regulations. But there was an express ouster. So it's that type of very child-centred, very fact-specific, very case-to-case focused analysis that Advocate General de la Tour is drawing on at 108. And I would invite you, much quicker than me reading it, if you haven't read it already, to read 108 through to 110. Now that is a test of clear case-by-case analysis by reference to the facts of the particular case, directed ultimately at the question, as the headnote to Chavez-Vilches says, of whether the effect would be, and this is the language used in Chavez-Vilches by the CJU, to deprive the relevant parties of the genuine enjoyment of the substance of their own rights under Article 20. And that, in our submission, is exactly the question that arises once you have a right of residence protected by Article 21. If the circumstances attending it are so miserable, are they such as to deprive you of the genuine enjoyment of the substance of the rights in question. And that's precisely the topic at which the much criticised passages of the Upper Tribunal decision were directed. My learned friend said it was without authority. It's not only without authority, it's supported by the Advocate General's reasoning in the case, drawing upon parallel analogous authority of the court.
Do you accept that those are directed to ones who've made applications for assistance rather than a general requirement to go out and interrogate the whole group?
Yes, I'll come to that when we come to ground two.
Sorry, well, if you come back.
No, it's a very good question, my lord, because what Mr. Koppel didn't explain to you, perhaps because he didn't appear below, is there were in fact two camps on ground two below. There was me and my clients who said, well, whatever the Secretary of State's Tameside duties of inquiries may be, whatever they are, this is a case in which there is obviously a duty of inquiry because the facts are the same as CG, if not worse. And whether or not there's a systemic problem with the regulation or practices under it, that's a matter for judicial review. We're concerned with the legality of the decision, and that question is academic. And you'll see that referred to paragraph 130 of the Upper Tribunal.
But the Upper Tribunal didn't accept that submission that you made,
No.
and they went further.
Equally, Miss Ward, for the Air Centre, was saying there was a general duty of inquiry, and the Tribunal struck something of a middle ground, because I think on any fair reading of what they did say, what they were concerned to emphasise was that the logic of the reasoning in CG in the court, which we'll come to, was not confined to people who could be labelled vulnerable. In other words, it wasn't just the victims of domestic violence or those with relevant disabilities or mental health problems, that the scope of the reasoning of the CJU was enough to embrace those who simply had a problem of living in abject poverty. That was their real focus of concern. And they were saying, don't read in, by reference to the vulnerabilities, a limit that is not, in fact, present in the full scope of the reasoning in question. How far it goes is to be developed in future cases. And in my submission, that's perfectly unimpeachable, because at the end of the day, the core reasoning in relation to ground two is about effectiveness, an inquiry into effectiveness, and with that, my learned friend had little sensible quarrel as far as I could see it. I'll come back to that. So, you've seen Advocate General de la Tour's analysis. Now let's see how that's carried over into the court's reasoning. The first thing to note is that the United Kingdom government, not for once on this occasion represented by Mr. Koppel, made a challenge to admissibility. And you can see that at 53 and following. And it's in the context of rejecting the admissibility challenge that the sidebarred passage, I think my learned friend relies upon. There is nothing here beyond effectively an indication that the matter is sufficiently in scope because it predates the withdrawal agreement and we're dealing with a matter of EU law for the matter to be a referable question of EU law at the time that it was referred. That's all that 57 and 58 are saying at this juncture. The real answer is in the substance, and the substance at 63 to 67, page 1693 to 4, is effectively to endorse, perhaps still more firmly, the reasoning that Dano and Alamanovich displaced the rule in Troiani. You see, and you've been shown these passages, a firm conclusion that the analysis in play is the Dano analysis, and any questions of proportionality are effectively automatically answered by questions of unreasonable burdens on the state's resources. Then, can I ask you to note paragraph 72, where they reformulate the question about the effect of Article 24.
Are you coming back to that troublesome little few words in 59?
Which trouble? I would do if I could remember what they were, my lord. Would you remind me, and then I'll deal with them.
CG's situation falls within the scope of the EU law until the end of the transition.
Yes, that's simply making plain that she has a right under EU law as preserved by Part 4, which is the only basis for the reference presently being made. And the court at this stage is not competent to deal with any question about the interpretation of the withdrawal agreement. First, because no question has been raised, and secondly, it hasn't been raised under Article 158 of the withdrawal agreement. So it could only be answering questions about whether or not this carries over if the National Court asked it such questions. It's just saying assiduously, we're answering the question that's before us in the circumstances that arises.
I think these words with the focus of the tribunal's comments and observations, I think, in some respects.
Yes. The tribunal looked at this when dealing with the préfet du Gers argument.
The voting case.
Yeah, which I note quite wisely hasn't been resuscitated orally before. I mean, it's a rank bad point that because the court has decided that you no longer...
Don't hold back.
Well, no, it is a rank. Because the court has decided that you no longer have the appendages of an EU citizen in terms of being able to vote in European elections.
I think it's just that the point there is that voting is not part of the WA, and therefore Article 51 can't attach to a right which isn't there.
That and the fact it's not a general principle, it's not something that can be used to interpret or give meaningful content to the relevant rights in question, because it's part of the political content of the Charter rather than the parts focused upon effectively rights. As you know, the Charter's split between rights and principles, and that's in the section confusingly called principles, even though the section called rights is general principles of EU law. But there we go. That's préfet du Gers. So 73 then says the case is not within the express derogations in Article 24, and then 74 onwards is the answer to the effect that that doesn't matter. The rule contained in the Lex Specialis that those who are economically inactive should not receive benefits is a general rule, and there is a general disablement in relation to that. And at 80, you can see, again, very clearly, a per se rule of justification that departs from the Advocate General's much more nuanced inquiry into indirect discrimination. 81 is probably the closest you'll get to the court actually overruling Troiani, where they say, I think this was the passage my learned friend Mr. Mitriou got up yesterday to point out.
That was in the AG.
Oh, right, well, it's to the same effect. It's 81 in both by happenstance. The assessment can't be called into question by the fact that CG has a temporary right to temporary residence under national law, which is granted without conditions. If an economically inactive union citizen who does not have sufficient resources and resides in a host member state without satisfying the requirements laid down in the directive could rely upon the principle, he or she would enjoy broader protection than he would have enjoyed under the directive, and that can't be. It's kind of classic non-circumvention reasoning. And that's the end of Troiani, without the case actually being expressly cited. But then the rest of the section, after 82 and 83, which addresses the Zielkowski case, and Article 37 of the directive, which says all of this is without prejudice to more generous national provision. The rest of it is a kind of, that said, here's a proviso, and it starts at 84 onwards. The first point to note is what is being said is that someone like CG who has moved to another member state has made use of his or her fundamental freedom to move and to reside within the territory of the member state conferred by Article 21(1), with the result that his or her situation falls within the scope of EU law, including where his or her right of residence derives from national law. So what they're saying is moving to reside, including moving to reside based upon national law, is within the scope of Article 21. And that's relevant for a number of reasons. It's relevant, in fact, first of all, to answer my learned friend's point about Article 21 makes no sense, shorn of the right to move. Because that bit of Article 21, in the context of the withdrawal agreement, is the work done by Article 10 of the withdrawal agreement. Because the whole focus of Article 10(1)(a) and following is to inquire whether or not you're a national of the EU and the UK or vice versa. In other words, have you moved relying upon your EU rights in accordance with EU law? So the very thing that my learned friend says is absent is already tested under the scheme of Article 10 of the Withdrawal Agreement. And that's the first thing that the court is concerned with. Have you moved? Once you've moved and you've got a right of residence derived from national law, they then say at 85 that the Charter's scope is defined by reference to Article 51, standard case law in relation to that. Charter and fundamental rights guaranteed by the legal order are applicable in all situations governed by EU law. And just stop there, parenthetically. Can there be any doubt that this is a situation governed by EU law? Well, hardly in circumstances where the whole of the court's reasoning beforehand is that Article 18 of the TFEU has been ousted by the more specific provision of Article 24 of the Citizens' Rights Directive. That whole analytical exercise is necessarily predicated upon the involvement of both the treaty and the CRD itself to the situation in question. 87. In the present case, it's apparent from the order for reference that the UK authorities have granted pre-settled status, more favourable rules, etc. In so doing, this is the critical part. This is effectively what I think described to the tribunal as the estoppel type reasoning. Those authorities, by contrast, recognise the right of a national of a member state to reside freely on its territory conferred on EU citizens by Article 21 without relying on the conditions and limitations in respect of that right laid down by the directive. In other words, they didn't stand on their rights to say you can't come in. They did the exact opposite and said, welcome in, we're going to give you a right of residence in any event. And because of that, it follows that when they grant that right in circumstances like that, the authorities of the host member state implement the provisions of the treaty on citizenship. That can only be a reference to Article 21, which is pointed out at 62 above, is destined to be the fundamental status of nationals of the member states. And they're accordingly obliged to comply with the provisions of the Charter. Now, I think it's at that point my learned friend says, citizenship, you're no longer citizens, and this is all about citizenship. And because you're no longer citizens, none of this reasoning can apply. Now, that argument is another canard with respect, because all of the rights adumbrated in Article 13 depend upon either citizenship or EEA EU nationality. The rights in Article 45, the rights in the CRD, every single one of them depends upon being a citizen or a national. And EU citizenship is simply defined by reference to having the nationality of an EU state.
Well, Article 13 confers rights on two categories of person, a Union citizen and a UK national. So
Yes.
they both have rights.
Yes.
The rights that they have are conditioned on those treaty provisions and subject to limitations.
Yes.
So you would naturally read those limitations and conditions in the case of a UK citizen, short of the notion that they're no longer an EU citizen.
Yes.
They're a UK national acquiring rights and subject to conditions set out in those other provisions.
Yes, but we're dealing with a...
But it doesn't matter that they are no longer a citizen, because you start with the notion you've got two categories, one of which is a citizen, one of which isn't.
Yes, and the whole purpose of the exercise is to preserve the rights for the citizen in relation to a state of which they are no longer an EEA citizen, and vice versa for a UK citizen in respect of a state of which they're no longer an EEA citizen either. So that sort of everything turns on citizenship reasoning really doesn't take one any further. 89, in particular, it's for the host member state in accordance with Article 1 of the Charter. So here's Article 1 being singled out for special effect, detached from, not as a rider to or a bolt-on to, detached from the other articles, to ensure a Union citizen who's made use of his freedom to move and reside, who has a right of residence based on the basis of national law, and is in a vulnerable situation, may nevertheless live in dignified conditions. So the starting point for the analysis is the autonomous effect of Article 1 of the Charter, not it in conjunction with everything else. Furthermore, Article 7 of the Charter recognises the right
And I
to...
just stop. This is one of the paragraphs which led me to think that what they're talking about, amongst other things, is you can acquire your rights if you've exercised the right of free movement, because this cast in the past tense, has made use of his or her freedom to move and reside within the territory of the member states, which at the time in 2016 or 2018 included the UK.
Yes.
So a triggering right is accorded here to someone who has exercised the basic right of free movement
Yes.
at an earlier point in time.
Yes, and as to that...
They stay on in a different capacity once the WA comes into force.
As to that, there can be no doubt that that is a substantive test met by CG, given her pattern of integration and work in the UK. AT, sorry. Given her pattern of integration and work. And indeed, her wish to return to work as and when her circumstances allow. So, then you come to 90. Furthermore, Article 7 of the Charter, congruent with Article 8, recognises the right to respect for family life. That article must be read in conjunction with the obligation to take into consideration, in all acts relating to children, the best interests of the child, which are recognised in Article 24 and the case therein cited. And I think I'm right in saying that Chavez-Vilches is cited in that case. I can double check. The host member state is required to permit children who are particularly vulnerable. So we've now got two categories of vulnerability, or two heads of vulnerability, the domestic violence and the fact of being a child, to stay in dignified conditions with the parent or the parents responsible for them. So it's about ensuring the relevant parent with care child unit can live in dignity. And then a factual inquiry. Now, this whole factual inquiry, my learned friend's analysis is right, that the Children Act is the answer to everything, it's a total waste of time. Because all they need to be told is that there is the Children Act providing reserve theoretical entitlement, and that's that. And that's the end of the matter. And I can, if it's assistance, supply to the court the letter that CG sent to the court in response to a question from the judge rapporteur, Judge Juremai, asking for the full details of CG's benefit position. And it detailed all of the benefits in respect to which CG was in receipt, including the various payments and charitable donations and the fact that she was, by contrast to AT, in receipt of a modest amount on a weekly basis from her local authority. Yes, and her... And, you don't want to see it. I think nevertheless it is relevant that there was such an inquiry and such generic information supplied, and we could probably leave it at there.
We just have to go on the facts provided to us by the court.
Absolutely, I totally understand.
That's the public analysis.
Yeah, of course,
the benchmark.
And at 92, those facts are then gone through with care. Now, they would be completely irrelevant if my learned friend's analysis is correct. And effectively, what they're doing here is analysing the needs of a mother with two young children who didn't have the resources to provide for her own and children's needs, and who is isolated on the account of having fed a violent partner. Here's the duty of inquiry. In such a situation, triggered by such a facts coming to your attention, the competent authorities may refuse an application for social assistance, such as universal credit. So we're straight away into the question of applying Article 21 of the Charter, of the TFEU in conjunction with the Charter. My learned friend says there's no question of application. That seems to be where the CJU goes straight to. Only after ascertaining that the refusal does not expose the citizen concerned and the children for which he or she is responsible to an actual and current risk of violation of their fundamental rights, as enshrined in Articles 1, 7 and 24. In other words, when confronted with evidence of a risk, you have to satisfy yourself that that risk will not manifest itself into a breach. And that can hardly be answered by a generic answer that says wherever there's a risk, it will be met by the Children's Act. In the context of that examination, those authorities may take into account all means of assistance provided for by the national law from which the citizen concerned and or his or her children may actually and currently benefit. And we've supplied the different language versions of these relevant passages. Possenong, it means literally are capable of, perv, are able to benefit, are in fact benefiting from. In the dispute in the main proceedings, it will be for the referring court, in particular, to ascertain whether CG and her children may benefit actually and currently from the assistance other than universal credit referred to by the representatives of the UK and Department for Communities in their observations. In other words, they were saying she will get support from the Children Act and matters like that, and therefore the risk won't manifest itself. In the light of the foregoing conditions, the answer to the question is as follows. And again, you go through the language of 93 and the dispositive, it is all focused on the actual and current risk of violation of their fundamental rights, whether or not they do in fact have resources to provide for their own needs, not needs in general, and those of his or her children, and whether or not they are isolated. And the national authorities must ensure that, in the event of a refusal to grant, that the citizen may nevertheless live with his or her children in dignified conditions. It's impossible to read this as anything other than an exercise focused upon the facts of the particular case in hand. And that is all the more obvious when you bear in mind the rights of the child context, the reasoning of the Advocate General, which has plainly inspired this exception, and the reasoning in Chavez-Vilches that sits behind it.
Can I ask a question at this stage?
Of course, ma'am.
Which is, how does this analysis in 92 and 93 differ from any complaint that anyone might make under the common law duty of humanity or Article 3 of the European Convention on Human Rights?
Well, I must confess I'm not an expert in the common law duty of humanity, but in relation to Article 3, the critical point is that the Hackbin test, building on the Jarrow test, is a concrete identification of the threshold supplied by the combined effect of Article 1 and Article 4 and Article 7 of the Charter. And the position is only amplified when you take into account the fact that in Hackbin, the relevant party, a single young man, wasn't a parent with care of a child. And it's that additional factor, I think, that goes to the heart of the flaw of my learned friend's Wensbury case. That's what it really is. He says, the facts are nothing like Hackbin, ergo you must have misapplied the threshold or acted perversely or unreasonably. It simply doesn't follow once you appreciate that Hackbin is a different case and there may be different basic needs depending upon the different factual circumstances of the parties in question. The basic needs of an 18-year-old young man are very different from the basic needs of a mother with a 3-year-old child in its critical developmental phase when she's got HIV. It's not comparable. The idea that it should be rough sleeping and some basic shelter and access to the food bank in both circumstances just doesn't follow as a matter of logic. So what we say in answer to my Lord's question is, effectively, you have the benefit of worked jurisprudence that shows you what the target is and what sort of facts fail the target. And it's that jurisprudence that the court supplied. It does seem to provide a more rigorous test than has been applied by our domestic authorities when applying Articles 3 and 7. And if that's the requirement of the combined effect of dignity with everything else, then that's the test that EU law obliges you to provide.
There are two separate questions. There's one, what is meant by dignity in a practical sense, which you get from Jawo and Hackbin, and you've got the tribunal's formulation of that in 125. I don't know if you agree that that's a reasonable application of how Article 1 would apply, whether standing alone with Article 3 or Article 4. And then you've got, assuming you've worked out what the level is, and I think everybody accepts it at least has the word basic attached to it.
Yes.
Then how does the state go about implementing that? Now, Mr. Coppell accepted it had to be effective. You've got to get to those who are individual. There may be many, many different ways of setting up a system in order to ensure that those who are relevant individuals get their payment.
There's two questions on it, my Lord. There's the first question, which is, what is the basic need for this particular applicant. And the basic needs may vary depending upon the circumstances of the applicant.
That's what the tribunal says in 125.
Yeah, but that's the logical flaw my learned friend falls into, because he says they're the same basic needs for everyone. That's just analytically unsupportable. And then there's the procedural question. After you've identified what the basic needs are,
how do you get the money to them?
How do you get the money to them? And in relation to that, I'll come to that, but if you want me to prefigure an answer, a state can't set up a situation of self-induced frustration to say, well, it's not my problem, it's the local authority's problem. They can't point to a remedy that it's excessively difficult in practice to exercise, because that's to impair the effectiveness of the EU rights in question. And we cited to the tribunal below the case of Impact, which basically says that where your EU rights require separate remedies to be taken from separate courts, that may impair the effectiveness of that right, and said that that's a test amply met in these circumstances, because the reality is we're being expected to live on a promise of that which may one day come after a judicial review through the Children's Act, but which is for present purposes illusory, and our client can't reasonably be expected to eat or clothe her child on the basis of promises.
Which is presumably why the authorities say judicial review is a wholly unsatisfactory way of implementing.
Correct, my lady, because by the time you get the relief, the damage has been done. That's the nub of it. And so that type of entirely theoretical exercise, we say, is just impossible to reconcile with the strong adjectival language of articles, paragraphs 92 and 93 in the dispositif. It's just not a real remedy. It doesn't stop you from starving. Now, take an extreme example, because my learned friend's case has to meet the extreme example. Suppose there was no support at all, that there was no roof over the head, that there was no food on the table. His answer would still be, in those circumstances, well, you're entitled to all of those things under the Children's Act. And because you're entitled to all of those things under the Children's Act, there's no problem. It can't be a question of, he hasn't suggested it's a question of fact and degree, that there's a point at which the Secretary of State has to take over because matters have got so bad. It's all or nothing on his analysis. It's all or nothing in his answer to my learned, my Lord Justice Dingemans, which is he has to say the findings of fact about the inadequacy of the Children's Act remedy is irrelevant, because at the end of the day, Section 17 can be expected to provide. So,
just on Tribunal paragraph 125, do you accept that's a reasonably fair? I mean, it's not intended to be definitional, but it's an indication of where the tribunal thinks the level of a dignity payment lies.
Yes, my lord, we do accept that fair. Indeed, I think the way that Hackbin came to be before the court is that it was put before the First-tier Tribunal by the Secretary of State, and we agreed before the Upper Tribunal that it was the relevant test. The test had been applied by the first-tier judge, and we said there was no error of law. And we said, what's more, you can't read Hackbin, paragraph 54, without looking at the analysis at 56 as to how the CJEU applied the test to the actual facts in hand. And that's every bit as important as the threshold test. Look at the inquiry in 56, and it's because Mr. Hackbin has lost a roof over his head, albeit only temporarily. It's because he's lost the support of the state, albeit temporarily, that the result has been triggered. The circumstances of our case we suggested to the tribunal and the tribunal accepted are worse. So we entirely accept the test at 125. We think that reading the whole of the Hackbin authority fully vindicates the approach taken by the Upper Tribunal. So, how do we apply all of this to the grounds? I can take this pretty quickly. I notice my lady smile with relief.
Yes, I'm just...
The proof is in the pudding, as ever.
So we're on to
Ground one.
number 5.
Yeah.
Ground 1.
the first point to note is we're through the gateway in Article 10.1a, and we're through on at least two grounds. Article 6 CRD and the fact that our client has the Article 21 right engaged by December 2020 after the grant of pre-settled status. Both of those things get her through the gateway. She may or may not have had a third basis, which was that at the time in question, she was in fact an economically self-sufficient person with CSI provided by the fact that the UK continued to be the relevant competent authority for the purposes of her health benefits, having worked here. We don't know. There was never an inquiry into that because the Secretary of State never inquired because they never addressed the impact of the withdrawal agreement or CG. The second question is then, are we within the scope of Article 13? And the answer to that is yes. The right in Article 21 is one of the rights, the Lego blocks adumbrated. So we're into that. She's got rights under Article 21. And that being so, is the refusal of the benefit some form of limitation or condition being applied? And it plainly is, for the reasons identified in the CG case. It plainly is for the further reason that this is effectively something that will, to use the language of Chavez-Vilches, taken to the logical extreme, deprive you of the enjoyment of the substance of the right of residence in question. That's the point at which the tribunal was directing its inquiry. There's no question of the Article 21 right being meaningless. It's all predicated on the right to move having been exercised beforehand. That's the test in Article 10. It's now the article right to reside part of it that we're looking at. The whole purpose of the scheme of Part 2 is to preserve that right to reside, just as the rights to reside founded on the CRD or Article 45 are preserved. It's completely irrelevant that there's no continuing right to move somewhere else, because that's not the focus of the withdrawal agreement. It's to focus attention upon the preservation of the rights to reside acquired by free movement in the state in question, and not to move thereafter. That's not the subject matter of the agreement. The whole citizenship issue is irrelevant, because the whole predicate here is you are maintaining these rights notwithstanding the fact that you've lost citizenship. The argument that somehow we're importing all aspects of the Charter are irrelevant, because it's only those parts of the Charter that contain rights that are used to police the limitations and conditions that the state may set upon your rights of residence that are of any relevance.
Just kind of to backtrack a moment, you said you retain the rights even if you lost citizenship. AT hasn't lost citizenship. It would be the other way around.
No,
a UK national going abroad would lose EU citizenship.
You've lost the right to assert your EU citizenship as regards the state that you're in.
Okay.
That's the point.
Right.
Sorry, I didn't express myself.
Yeah.
So the Charter is being capable of being applied. It's a method. It's a means of interpreting or applying the relevant limitations and conditions upon the right of residence. That's what the Charter has always been used for. Cases like ERT, etc. They're just classic instances of using general principles to control limits the court seems to set on the rights of free movement in question. And that's as true as residence rights and social security, SOCIO, CG, as many other forms of restriction. And the proof of that pudding is Article 13.4 sitting in the background saying you shall not attend residence with any conditions not authorised under the scheme of the treaty. As to which point, I should remind you that, of course, that very topic of recourse to social assistance is addressed in the terms of the CRD itself in relation to economically inactive people. And the basic rule is, Article 14, 14.1 deals with the 3-month initial period. You shall have the right of residence, provided that you don't become an unreasonable burden on the social security system in that first 3 months. And then 14.3 provides an expulsion measure shall not be the automatic consequence of a union citizen's or his or her family member's recourse to the social assistance of the host member state. And what that tells you is that for the economically inactive person in Article 7, the fact that having hitherto been self-sufficient, you're nevertheless temporarily driven to claim social assistance, is not enough reason to bring about the termination of your right to reside and to expel you from the territory in question. And it shows you that this whole topic of loss of residence rights or denial of residence rights is totally tied up with the question of social assistance and the courts to social assistance. So, that being so, I have to say that my learned friend's careful recount of the greatest hits of social security law, Dano and Alamanovich and Merger and HC, is largely irrelevant. All that needs to be said in relation to Dano and Alamanovich is the CJU qualified the scope of its ruling in very clear terms. That's the law. Get over it. Effectively, that's the beginning and end of the matter. All that needs to be said in relation to Merger, which was a Dano and Alamanovich case, is that that's now subject to the exception in CG. Get over it. And my learned friend's attempt to invoke the relevant passages in Merger, in particular paragraph, I think it was 41 and 46 from the speeches of Lord Neuberger, are in fact irrelevant for a number of reasons. First of all, those passages are directed at a completely different question. They are directed at the bombast question of proportionality of response as to whether or not something is an unreasonable burden on social security. They are not directed at a human rights test at all. And all that Lord Neuberger is contemplating is that there might be exceptional cases whose facts are very close to that of bombast, where this rule, as a general rule, is unjustified because somebody is so deeply integrated in the state that it's unreasonable not to treat them as being so. That's the first point. And the second point is that whatever he says about the irrelevance of being effectively compelled to leave the jurisdiction is to be viewed in light of the fact that in Merger, neither Miss Merger or Mr. Samin had any relevant right of residence. The thing that they were complaining about was effectively their inability to take social assistance to continue to be lawfully present in the UK. They had no relevant right of residence. The difference here is that my client has foursquare the right of residence preserved by Article 13, and she had the right of residence as a matter of EU law from December 2020 when PSS was first granted to her. So it's an apples and pears comparison of reasoning in relation to a case where there is no right of residence to reasoning in relation to a case where there is. You make this simple point. If you make the conditions of enjoyment of a right of residence so unpleasant that no one can practically enjoy them, you're not really conferring a right of residence at all. And that ultimately is the position to which CG boils down to. HC, the last part of the biannual Richard Drabble, Jason Coppell Ducathon, is equally irrelevant. What?
The what?
The Richard Drabble, Jason Coppell Social Security Ducathon.
What's a Ducathon?
Annual trip to take lumps out of each other in the Supreme Court. There's a rich case law between these two doughty fighters. It's completely irrelevant.
Leave him alone.
I'm really affectionate. It's completely irrelevant. Beyond the realistic recognition in the speech of Lord Carnworth and Lady Hale as to the practical limitations of the remedy under the Children's Act. It's only described in those speeches as something that is very much the last resort. And it doesn't answer the questions that arise here about what do you do faced with somebody who is in the desperate or dire straits that confronts my clients. So we don't think that any of that illuminates matters. Still less, and this was the claim my learned friend made, we don't think that any of that has any bearing whatsoever on the text of the withdrawal agreement. There's simply no trace of Dano and Alamanovich and the reasoning it contains, or Merger and HC, in the language, configuration and structure of the rights in question. It's been designed against a completely different target. The fact that that might have been the combined effect of EU law and domestic law is irrelevant unless it has some bearing on the issues of construction. So for all those combined reasons, and for many of the other excellent reasons in support from my learned friend Mr. Dimitri and Miss Ward, we think that ground one is bad, and the obvious conclusion that the law is...
You haven't heard them yet.
I've read them. And as you'd expect from the three eminent names on one skeleton and the two eminent names on the other, they're full of good points and learning. Ground two, individual assessment. At times, it was difficult to understand the boundary lines between the arguments in ground two and ground three. They seem to allied with each other quite substantially. There is, I accept, the prior question of what cases does the obligation to conduct the assessment identified in CG bite upon. And I stand by the answer that I gave previously to the Upper Tribunal. It is sufficient for our purposes if this is one such case. That's all that needs to be asked, because effectively from that flows the error in the decision and the ultimate soundness of the FTT's conclusions, albeit reached by the wrong routes instead of through the withdrawal agreement through the European withdrawal agreement 2018. So I don't need to go any further than that. And to an extent, the questions about what tameside inquiry, what form of warning letter, what category of case might this be a problem for, is a relatively potentially dangerous adventure that should just be explored in subsequent case law. It may well have to be explored in subsequent judicial review if there's systemic problems with the manner in which this question is approached presently. And we don't know what the Secretary of State's changed arrangements will be to address the consequences of this appeal if it's rejected, because we haven't got the new procedures which will necessarily be required. The second order of this is the idea that somehow all of this, my learned friend waxed lyrical on this subject, all of this is a wholly novel exercise of the type that the DWP is not equipped to undertake, and big changes, etc. We don't, I'm afraid, for a moment accept that that's correct. The first point is, have a look at section of Regulation 116 of the Universal Credit Regulations, which is referred to in the Tribunal's judgment, paragraph 137. You'll find those in the authorities bundle, I think it's tab 9. And Mr. Watson reminds me, page 118. So Regulation 9 is the habitual residence test, applicable here.
Sorry, on paragraph 137 of the judgment.
Yes, it's 137 of the judgment refers to the hardship test under the Universal Credit Regulations. And you'll find those in tab 9 of the authorities bundle.
Do you want us to turn this up?
Yes, please.
Certainly.
Page 118 to 9. I don't know if any of the members of the court have had to deal with benefit sanctioning, but you're familiar presumably with the general contours that if you don't do what you're required to do in terms of work seeking, interviews, placements, etc., you can have your benefits withdrawn. And this scheme is effectively a scheme to mitigate the harshness of that by providing for hardship payments. And the nature of hardship payments are set out at 1162. The inquiry is as to whether or not the claimant is in hardship because they cannot meet their immediate and most basic and essential needs specified in paragraph 3, or the immediate and most basic and essential needs of a child or qualifying young person for whom the single claimant or either of the joint claimants is responsible, only because the amount of their award has been reduced. And the needs referred to are accommodation, heating, food, and hygiene. Now, that is, with respect, precisely the same sort of inquiry as is required by the CG individuated inquiry. It's exactly the same sort of exercise. It's basically directed at whether or not you're going to be forced to live in unacceptable destitution. The idea that this isn't something substantial within the bailiwick of the DWP is unreal. There's, I think, something in the order of, my learned friend Mr. Royston dug up the figures for me, 1.81 million universal credit claimants who are at risk of a sanction, of whom 6.5% are subject to sanctions. In other words, at any one point in time, there's 118,000 people who can invoke this regulation and seek hardship payments. It's 118,000 a month. How many actually make that application, we don't know. But there... I'm told by Mr. Royston that we know from the same sort of statistics there's 9,000 payments a month made under these regulations. Whatever the figures are, and they are the sorts of matters well known to the expert tribunal that was the Upper Tribunal. And that's why it referred, at our instigation, to these regulations and said it was a relevant analogy. There is a large cohort of people for whom exactly the same sort of exercise has to be undertaken. And that's just within the DWP's bailiwick. The same point could be made in relation to the no recourse to public funding applications for waivers. The only difference there is that it's the Secretary of State for the Home Department who considers those waivers, rather than the DWP. But again, there is a very sizable exercise, and from the figures I've seen, it spiked for obvious reasons massively over COVID, as people lost employment or were faced with unexpected costs. There were huge spikes in applications for NRPF waivers. And as I've indicated, there's a whole scheme dedicated to the victims of domestic violence seeking such waivers. So the idea that this is some kind of incongruous, uncertain, novel, dangerous, unbounded exercise is, with respect, not fair or accurate. And that being so, it may well be that there are some of the consequences that my learned friend describes in terms of how to grapple with this on an institutional and procedural level. But ultimately, that is no answer to the duty that has been placed upon the United Kingdom by the analysis in CG. That leaves only his...
You're not asking us to flesh out what implementation stages the SSWP would be required to take.
No.
We've had discussed, and we have to be very careful
No.
about trespassing into areas that we really have no...
Absolutely. And I've always said, and I consistently say, that that might be a matter for a subsequent judicial review if the arrangements are insufficient or inadequate. But we're just nowhere close to that. All that's required in this case is the relevant analysis, and the analysis in this case has been done by the FTT and then the UTT, and they have identified a basis in this case to remedy the problem. And the only remedy that's presently available is to disapply the regulations, the updating regulations on the facts of this case. And that takes me to answer a point my Lord Justice Green has made on a number of occasions. There is obviously latitude for the Secretary of State, if they want, to introduce something akin to hardship payments that are short of full universal credit. There's obviously latitude to do that. As and when the Secretary of State does that, that may well supply the answer, but that doesn't presently exist. And therefore, all that is available at present, in order to avoid the breach identified by the tribunal, is the disapplication on the facts of AT's case of the updating regulations and their requirement that she have a right of residence other than PSS. That's the only remedy that is available. And that was actually common ground below. That was the only way that the breach, if found, once identified, could be remedied on the facts of this case. So, yes, of course, Secretary of State may, going forward, choose to do all kinds of things short of giving full universal credit. But unless and until that is on the table, it's speculation as to whether or not it's adequate or not. You can only grapple with what is possible. So that is, with respect, ground 2. And the argument that all this can be shipped off to the local authority is no kind of argument at all. From the perspective of EU law, the state is indivisible. It's the state that's accountable for the breach. And the state is no more concerned with internal allocations in this as it is in relation to Frankovich or all kinds of other areas of breach. If there isn't that which that should be provided being provided, then it must be provided in the way available, and that's disapplication. So then, ground 3, I think I've largely dealt with that. It's no answer, particularly when faced with a requirement of effectiveness, to point to purely theoretical remedies. It's the point that the tribunal makes at very considerable length and in very careful reasoning that the focus necessarily in the judgment is upon the practical and effective nature of the support provided, not some theoretical or illusory remedy. And that analysis with respect has to be right. You can test it logically this way. Start with a request to the only authority. Let's imagine in Hackbin you got nothing. There was only one authority that could give you the money. Could you answer the claim? And I admit this is ridiculous. Could you, as the authority, answer the claim by saying, well, you're entitled to it, so I haven't breached it even if I hadn't given it to you? That's laughable as an argument. Does it make
Mr. Coppell accepts that the remedy's got to be effective.
Yes.
I mean, he didn't challenge my 4 fairly elemental propositions, just really about state responsibility. I mean, this is part of the problem of speculating as to what might be.
But your elemental propositions with respect to are entirely the right ones, and they're entirely the thought process that you see if you track through the impact case. It's not enough to be able to point to the theoretical availability of a remedy. The practical reality is it's too difficult, expensive, or time-consuming to obtain relief under that for it to provide any meaningful remedy to the solution of your problem. And as my Lord Justice Green knows, I mean, EU law is fixated with the effectiveness of remedies at the end of the day. They've got to be real, not illusory. And this is an argument that flies in the face of that proposition. So then that takes one on to ground 4, the question of threshold. And this argument has morphed. It's not actually what it says it was. It's not an argument about the wrong threshold having been applied, because the tribunal has identified and tabulated the very threshold in the CJEU case law that grapples most closely with this issue. It's done so at the initial instigation of the Secretary of State, and then the UT has basically approved the citation of authority by the FTT. It's not a complaint about the threshold at all. It's a complaint that says, because that's the threshold, and because these are the facts, we can infer that you've misapplied the test. In other words, that you've acted irrationally. You've arrived at a rational conclusion that this is the sort of stark case that would breach the requirements of dignity. Now, first of all, that's not the ground identified. Secondly, that's an extremely ambitious argument to be making in respect of an extremely experienced and expert tribunal. And I can rehash all the Secretary of State's usual arguments, because it's the Secretary of State who's usually making the submission I'm making now. And they do apply with force to an upper tribunal composed of a High Court judge and 2 of the most expert lawyers in the social security system. There is a very careful review of the facts in the case. There's obviously great appreciation of the facts, not least because the UTT was troubled by about 5 other factual appeals from the FTT decision, which haven't been pursued here. And the argument, when you strip it back, actually proceeds on the fallacy I identified earlier, which is to say that because the basic needs in Hackbin are identified as X, Y, and Z, the basic needs of a mother with HIV with care of a 3-year-old child must be the same, and it simply doesn't follow. What my learned friend has to do, ultimately, is to attack the conclusion that facts as stark as these don't amount to a violation of dignity. And I'm afraid, given the starkness of the facts, he's nowhere close to meeting the threshold of Winsbury in relation to that task. Unless there's anything, I'm just going to check with Mr. Boyd. Unless there's any other questions the court has, somewhat earlier than promised, I've managed to do it in 2 hours rather than 2 3/4. Horrible creep that I am.
Anything else? No, thank you very much. No. Yes.
May it please the Court, as you know, the Independent Monitoring Authority has intervened on ground 1 only.
Yes.
And I really think I can be very brief in light of the submissions that you've heard, but I do want to lay out what the IMA's position is on ground 1. And I think the starting point in terms of identifying the issue is paragraph 95 of the Upper Tribunal's judgment at page 131, where the Upper Tribunal noted that AT's situation is similar to CG's in that she moved to the UK and was granted PSS at a time when she enjoyed rights under Article 21, as made applicable by the withdrawal agreement. The difference is that she applied for universal credit after the end of the transition period. Everyone agrees that even after the end of the transition period, the WA made some EU law applicable. The question for us is whether the changes that occurred at the end of the transition period were such that the Charter was no longer applicable as it would have been if she had made her application just over a month earlier. That really is the question that ground 1 raises. And in response to that question, we say that the Tribunal got it absolutely right. And then just looking at what CG establishes, without going back to it, because now you've seen it a number of times, but there are really 3 stages. So the first stage is that where a union citizen has moved to another member state, they've made use of their Article 21 rights such that their situation falls within the scope of EU law. And we see that from paragraph 84 of the CG judgment. Second stage is that where the UK has granted a right of residence, even though the person doesn't have sufficient resources, so even though they don't comply with the requirements in the CRD, that right of residence is not granted under the CRD because the conditions aren't met. But in granting the right of residence, the UK has recognised the right of the person concerned to reside in the UK conferred by Article 21 without relying on the conditions and limitations contained in the CRD. And we see that from paragraph 87. And the third proposition is that it follows, the Court of Justice held, that the UK has implemented Article 21 of the Treaty of the TFEU, and the Charter must therefore apply. So in granting the domestic law right of residence, the member state must act in accordance with the Charter by ensuring that the claimant lives in dignified conditions. And we get that from paragraphs 88 to 89 of CG. Now, transposing those 3 propositions to the post-transition period raised by this case, the result is exactly the same because the same principles apply, albeit via a different legal mechanism. In other words, via international law rather than via the EU treaties directly. So first of all, AT exercised in exactly the same way as CG, exercised her EU free movement rights in coming to reside in the UK before the end of the transition period. So as Mr. de la Mare said, she's clearly within the scope of the withdrawal agreement, see Article 10. Secondly, the UK granted a right of residence, PSS, before the end of the transition period without insisting on compliance with the conditions in the CRD. And what CG tells us about that is that in doing that, the UK was recognising the right of AT to reside in the UK, that right being conferred by Article 21. Now, the transition period has come to an end, but Article 13 of the withdrawal agreement ensures that AT continues to benefit from a modified form of her Article 21 rights. So the position is materially the same. And there is accordingly no gap in protection. So as in CG, having granted a residence right under domestic law, the government is acting within the scope of AT's preserved Article 21 rights, preserved by Article 13 of the withdrawal agreement, when deciding her benefits application. And again, as in CG, the Charter continues to apply to ensure that the residence right conferred on AT guarantees that she may reside in the UK in dignified conditions. Now, the mechanism for the application of the Charter is slightly different, but the result is the same. So, in particular, the Charter doesn't apply precisely in the way that it did before the UK left the European Union, but it does apply for these purposes via Article 4.3. So that's really those are really the steps by which we say, the Independent Monitoring Authority says, that the result is the same despite the difference in the facts, namely that the application for benefits was made after the end of the transition period. And the court can sense check that outcome in my submission by standing back and asking itself this question. There is no factual difference, apart from the date of application for benefits, between the situations of CG and AT. And is there anything in the withdrawal agreement which indicates that they should be treated in a different way simply because CG's application for benefits was made before the end of the transition period and AT's was made after? And we say the answer to that is plainly no, because all of the relevant rights that underpin the reasoning in CG have been preserved. That's plainly the intention of this agreement. So that's in a nutshell why we say that the tribunal was correct to reach the conclusion it did under Ground 1. I want to now briefly turn to address the key arguments made by the Secretary of State. And I'll do this by reference to the 3 stages of the tribunal's reasoning, which is how Mr. Coppell approached the submissions. And I can be very quick because some of this is covering the ground that Mr. Dingemans covered, but I just want to explain our position in a nutshell. So the first point that the Secretary of State raises relates to the scope of Article 13. So the Secretary of State argues that Article 13 does not preserve any Article 21 rights. And we say that that's an incorrect argument, clearly incorrect argument, in view of the express wording of the provision, which incorporates Article 21. The Secretary of State's argument appears to come down to 2 points. The first focuses on the wording of Article 13.1, and you heard the submission that because of the wording, that appears only to preserve the limitations and conditions rather than the right itself. And we say, well, that's obviously wrong. Article 13.1 is preserving the right. I think we get that from the wording itself, because it talks about the right. But even if that weren't clear, it's made amply clear by 13.2 and 13.3, which Lady Justice King put to Mr. Coppell in the course of his submissions. And we say it's nonsensical to suggest that family members have the right in Article 21, but that the EU citizen or the UK citizen does not. The second argument made under this head is that Article 21 contains other facets or other rights which can't have been preserved by the withdrawal agreement, including the right to move freely across the territory of the EU. Now, we agree with that, but we say that the consequence is not that Article 21 is jettisoned completely, because that flies in the face of the wording of Article 13. The consequence is that that bundle of rights, that those aspects of the rights that don't make sense in the post-Brexit world are not maintained. But those that do are. That's really the answer to that point. The second stage of the Secretary of State's argument is really reduced in importance. That relates to the application of the Charter. And the debate on this has, as Mr. de la Mare said, become somewhat arid in light of the Secretary of State's concession that certain Charter provisions, including Articles 1, 4 and 7, themselves constitute general principles of EU law and so do fall to be taken into account via Article 4.3 of the withdrawal agreement. And so it follows from that the debate between the parties on this point doesn't seem to matter for the purposes of deciding the present case. But as a general proposition, the IMA's position is that it's a general principle of EU law that a member state acting within the scope of the treaty, including interpreting and applying Article 21, must act in a manner that's compatible with fundamental rights as codified by the Charter. And the court will know that this principle goes back a very long way, certainly a long time before the Charter was agreed. And the court will probably recall cases like the ERT case, which is back in 1991, where the CJU, ECJ then, held that fundamental rights form an integral part of the general principles of law, and established that member states, when they act within the scope of EU law, have to comply with those general principles, which are informed by, at that stage, primarily by the ECHR, but also constitutional traditions of member states and other international instruments. And when the Charter was adopted, then that became the primary source of fundamental rights for the purpose of the application of that general principle of EU law. And we've referred in our skeleton argument to the UBS case. Perhaps take that up very briefly. It's in Authorities 3, tab 49, Authorities 2, I think it must be, tab 49. And if we go to page 1354, and really I just wanted to show you the sidebarred paragraph 53. So it should be borne in mind that in accordance with the general principle of interpretation, an EU measure must be interpreted as far as possible in such a way as not to affect its validity, and in conformity with primary law as a whole, and in particular with the provisions of the Charter. Now that's interpretation of EU law, but that general principle applies also to member states, both when they're interpreting EU law, but also when they're acting within the scope of EU law, and that's really very well established, as I say, going back to the ERT case. And so, turning to Article 4, 3 of the withdrawal agreement, Article 13 is a provision for the purposes of Article 4.3 of the withdrawal agreement, which refers to union law. It refers materially here to Article 21. And so when the UK is interpreting or applying that provision, so interpreting or applying Article 21, it must do so in a way that complies with the general principles of EU law. And one of those general principles is that the interpretation and application of provisions of EU law should be in compliance with the Charter. So we say that that it's in that way that the Charter, that's the proper analysis for understanding why the Charter is applicable in this context via Article 4.3. Now, the third stage of the Tribunal's analysis and of Mr. Coppell's submissions relates to paragraph 106 of the Upper Tribunal judgment. And the Secretary of State says that the UK, in deciding whether or not to grant universal credit to AT, was not implementing or applying AT's modified Article 21 right to reside. That's the Secretary of State's argument. And that submission, we say, is completely inconsistent with the court's judgment in CG, because CG establishes that in granting PSS, in granting the right to reside, the UK has acted within the scope of Article 21. In other words, it's applied Article 21. And CG establishes that when the UK is conferring that residence right, applying Article 21, then it must confer it in a manner which is consistent with the Charter, and in particular with those provisions which enable the claimant to live in dignified conditions. So, so for that reason, we say that, that submission is simply wrong and inconsistent with CG. And then finally, we turn to Article 4.1, which was the additional reason relied on by the Tribunal. Again, we say the Tribunal got this right too. the tribunal was right to find that Article 4.1 reinforced its conclusion under Ground 1 because that provision essentially guarantees reciprocity and it requires, in very broad and general terms, that the provisions of the withdrawal agreement be given the same effect in the UK as in the EU. And the Secretary of State's argument here, we agree with what Mr de la Mare said about this, seeks to narrow the generality of the language in the first paragraph of Article 4.1, somehow restricting it to the mechanism through which the provisions of the withdrawal agreement are given effect. But it's not a provision just about mechanism. It's a provision in terms about the legal effects of provisions. And so it says, shall produce the same legal effects. And we say that plainly, just as a matter of plain language, encompasses substantive effects. And the next paragraph, which refers in particular to direct effect, is really a subset of the much more general obligation. So those I hope, in a nutshell, are our submissions. Those I hope summarise concisely the position of the Independent Monitoring Authority on Ground 1. As I say, I, unless you have any further questions, you've heard a lot on the point, and so I don't want to take up more time than I need to, but I'm very happy to answer any questions the court may have.
Concise and comprehensive, every judge's dream.
Thank you very much.
Anything else? Thank you. Yes.
My lady, my lords, on behalf of the Air Centre,
Yes, thank you.
I hope you'll be glad to hear that I don't propose to take up any more of the court's time on Ground 1. You have my submissions.
We have, and we've read
our submissions on that in paragraphs 30 and 35. Yes. And insofar as they required oral supplementation, I think that's been adequately and admirably done already. So what I'd like to briefly address you on behalf of the Air Centre is what that means in practice. My Lord Justice Green has expressed interest in what the scale of this problem might be. And of course the Air Centre can't give the court comprehensive information about all of those affected. But it is able, in its application to intervene both below and in this court, gave some numbers. The witness statements haven't made their way into the bundle, but the witness statement of Mr. Evans of the Air Centre is quoted at paragraph 29 of our skeleton argument. And the same numbers were before the Upper Tribunal and can be found at paragraph 76 of its decision. What is missing from the quotation at paragraph 29, but is in paragraph 76 of the Upper Tribunal, is the number of cases in which the Air Centre provides advice to those with PSS about benefits. And that's 10 to 12 a month, so up to about 150 per year. And of those, in the year to September 2022, 21, so about 14%, were not exercising what would otherwise be a qualifying right of residence. And 11 of those 21 were domestic violence victims.
Sorry, how many 11?
11 of the 21 were victims of domestic violence. The majority had caring responsibilities, and 6 had illness or disability that prevented them from working. So that is the cohort, like AT, like CG, with whom this appeal is concerned, a small subset of a small subset, but nonetheless extremely important to the individuals who are potentially affected. And in the light of that, I ought to say something about the question of individualised assessment, because I rather feel now that this is a hare that we might have set running, or at least at the Upper Tribunal, accepting what I said below about that has created a situation from which Mr. de la Mare quite understandably wishes to step back and say, well, it's academic on the facts of this case. And of course it is, because AT is, on any view, an extremely vulnerable person. But the submission that was made to the Upper Tribunal on behalf of the Air Centre was never, you must conduct a full assessment in every case. You must conduct interviews. Mr de la Mare and I made the same submission to the Upper Tribunal, which is that it's for the Secretary of State to determine how he complies with any duty. I think my submission only, if it did at all, differed from Mr de la Mare's to this extent, that there is not some subset of the vulnerable in relation to whom this duty applies. But ultimately what you're looking for is that vulnerability that is going to create a risk of not being able to live in this country in dignified conditions.
If you're in a situation where you don't have dignity, are you by definition vulnerable? Or is... I mean, I'm just wondering, I mean,
Yes.
I think probably Mr de la Mare's right, that probably most people who are in this situation will be vulnerable in some sense.
Yes.
But there may be people who temporarily fall into a situation of destitution who are not otherwise vulnerable.
Yes.
But they may be vulnerable simply because they're now destitute.
Exactly that. Exactly that. And it's not, in my submission, going to be difficult. Mr de la Mare's drawn your attention to the hardship payments regulations. The regulation before that in the bundle, Regulation 9, which is about the habitual residence test, of course requires quite detailed consideration of the individual facts of any individual claimant in the course of determining their entitlement to benefits at all. So it's not a question of a situation where there's merely a box-ticking exercise, a very bright line rule, and sort of put it through the sausage machine in every case. These are decisions that require decision makers to have some knowledge of the law and to gather information about the circumstances of the individuals concerned in order to make those decisions. And to add on to that, is there any reason why you can't work? Do you have dependent children? Are you a victim of domestic violence? Is not in my submission imposing the kind of enormous burden that my learned friend for Secretary of State perhaps suggested it might do. So that's individualised assessment. And I say as well, we say as well, at paragraph 39 of our skeleton argument, that this isn't some kind of radical departure. Of course, Mr de la Mare has taken you through in detail how the CJU and CG reconciled the line of case law, including Alamanovich, and the indication there that bright line rules were, in general, both desirable and permissible. But as we've set out there at paragraph 39(2), there are other cases, and Bray, which and then for Mr Coppell rather skipped over, which suggests that there are circumstances, there have always been circumstances, in which a less bright line approach might be appropriate. And the factors that were suggested may be taken into account there included not only the sorts of factors that Lord Neuberger referred to in Meerger, such as the temporary nature or the closeness to missing the criteria of self-sufficiency, but also personal circumstances more generally. So this isn't the first time that the question of what does analysing the particular hardship in a particular case has come before the court.
Can I just ask, when the Air Centre gets the 10 to 15 applications a month, does it always go to EU law, or can it use the other remedies that are available, Article 3, etc.?
But the Air Centre will advise its clients on what remedies are open to them. So I do, and I will come on to this, come before you with something to say about Section 17 and the difficulties of that. I don't understand the Air Centre to take cases directly under the Children Act. And then a junior, I'm sure. Yeah. So they'll only advise on EU law specifically, but they can, of course, refer on or indicate where there may be other potential remedies. And turning to then those other potential remedies, I do just would urge on the court to be very careful not to say anything that either over or understates the potential role of Section 17 more generally, because the Secretary of State comes before you and says, well, Section 17 can solve everything, or the various local authority duties can solve everything. He hasn't put in any evidence that explains how this works in practice. I fully understand that the Compass paper, which appears in the authorities, as Mr. Coppell fairly indicated, without any resistance on the part of the Secretary of State at tab 68, is not formally before this court in evidence. And I say, I don't ask you to accept its contents as the truth. What I say is, well, the Secretary of State has not put before you any evidence of how this works in practice, or that it can work in the way in which he seems to envisage, or does work in the way in which he seems to envisage. And I can say, at least there is some evidence that that isn't the case. It's not something he can ask you to take judicial notice of. It's not an accepted state of affairs. My lady asked whether there are cases in which, on a semi-long-term basis, families are supported, and there are. There are, where accommodation is provided in small subsistence payments. They are not, however, the norm, and they are not necessarily easy to persuade local authorities to provide. And we've put in the case of Blackburn Smith. Don't ask you to turn it up, but what it shows is that, well, two things. Firstly, that local authorities considering these cases will consider a range of solutions, which may include taking the children into care and arranging for travel back to country of origin. And neither of those, in my submission, even if they were found to be Human Rights Act compliant, could possibly meet the issue in this case of giving effect to the right of residence under the withdrawal agreement. Secondly, the test, and then of course there is ultimately the Human Rights Act duty in such cases, and therefore the court will inquire into the facts perhaps slightly more than a straightforwardly conventional Wednesbury judicial review. But ultimately, those are the parameters of enforcing that duty. My learned friend referred to complaints processes and going to the Ombudsman. I'm not entirely sure how a complaint of maladministration is likely to trigger a local authority to put in place these sorts of arrangements. But when it comes to judicial review, of course, and as the Supreme Court was well aware, in what were, and should be noted, obiter comments in HC, in which it's expressly stated there was no detailed argument on what could be achieved through Section 17, getting to court on a judicial review is, and in my submission, the court can take notice of this, markedly more difficult for an unrepresented individual than accessing the Social Security Tribunal. But, Lady, my Lords, I would urge the court not to get too involved in the detail of what can or should be provided under Section 17, in the absence either of a claimant making a claim under that section or a local authority seeking to resist it. One final point on ground fee, and it's only because Mr. Lemaire and I have an ongoing, not sure if rivalry is quite the word, but desire to show off our linguistic abilities. And he referred you to the French and the Italian per, I think, and posso. Can
you give it us in the Finnish?
No, but I can do the German, which is in the bundle. And it's in the German, it's tatsächlich, what is, which again is absolutely actually a physical thing. I mean, for a German linguist, it's actually quite a visceral thing, tatsächlich. It means real. And that is, again, in my submission, shores up my learned friend's point that one can't eat.
So this is the actual and current expression.
Yes.
Actual, because I wrote down actual equals real question mark. So I was trying to work out the difference between the two. But the actual does mean real. Current means it's happening now, not just in a week's time or 2 weeks' time. You've got a current need.
Yes.
So it's real and immediate.
Yes. Tatsächlich in Anspruch is the German, so you're really in your grasp.
Right.
And
That's much better than Mr. Delamese.
I said an intervener is.
Yeah.
Well, I think an intervener is sometimes thought to seek to add colour, and I'm not sure that's necessary in the circumstances of this case. But I'll leave it there on the linguistic point, unless I can assist further on anything in particular.
Do you have any indication? I mean, you've given us an indication of the number of cases going through your client on a monthly basis. Is there any idea in the document of the scale of the problem? We have a rough idea of the total number of individuals with SSP. One imagines it's a relatively small percentage who would be vulnerable in the sense we're talking about. But with no idea if it's 1%, 10%, 5%.
If it helps, Manuel, from the publicly available figures we can see, that in the order of 3,500 people a month are refused on residence, UC or other benefits on residence-based grounds. That's right.
But we don't know what percentage of those
No,
are.
so whatever the cohort of people who benefit from CG analysis will be a subset of that 3.5, as against the 100 and whatever 60,000 that are subject to potential hardship payments analysis. It's a much smaller cohort.
And what the Air Centre's figures perhaps suggest, and obviously one can't extrapolate too far from a sample size of 150, but is that quite a large number of those, 80% of those approaching the Air Centre do in fact have what would otherwise be a qualifying right to reside, and perhaps something has gone wrong with the decision-making process. And then it's most of those that do seem to be vulnerable in some way.
So in terms of scale, we might be talking about 30, 40, 50,000 or more. We're not talking about millions.
Absolutely. And what we're also unquestionably talking about is a diminishing cohort.
Of course.
Because obviously those with PSS will graduate on, and subject to whatever arrangements are put in force to give effect to the IMA judicial review judgment. But yes, there will be a diminishing cohort of those with limited leave.
Thank you very much indeed. Yes, Mr. Coughlin.
Lady, I can make a start.
Would you prefer to gather your thoughts and talk to your team and wait till the morning, or would you rather get underway now? Entirely.
Can I deal with grounds 3 and 4 or 4 and 3?
Do.
And then I will need to talk to my team and sort through
Quite understood. You've 3 against 1.
Various instructions that I've been receiving.
Yes, so we're going to deal with grounds 4 and 3.
Yes, I just had a few points that I am confident that I can make about my learned friends' submissions. My learned friend Mr. Delamere submitted, if I start with ground 4, take them in reverse order as it were, he submitted that this ground had morphed, had changed into a rationality challenge, and it was never that. I don't accept that. I don't accept there's any inconsistency between what I've said to you today and our grounds of appeal on ground 4 on core bundle page 15. This was always a challenge both to the Upper Tribunal's legal reasoning as to what Article 1 of the Charter added, and as to whether the threshold, which no doubt was identified both by the Upper and the First-tier Tribunals, whether the threshold was actually applied. Now, I don't, in making my criticisms, call into question at all the expertise of the Upper Tribunal, or indeed the First-tier Tribunal. The problem that I point to is not one of expertise, but of reasoning. What the First-tier Tribunal did, we say, is to say that it recognised the high threshold from cases such as Hackbin, but then never to confront the contents of the test in Hackbin and seek to identify the basic needs which, in the First-tier Tribunal's rule, were not being met. In the First-tier Tribunal's view, were not being met. What you see is a whole series of evidential findings, followed by, I recognise the high threshold, and, well, this seems pretty bad to me, could even be inhuman and degrading treatment. That's in my submission what it amounts to. No confronting of the test itself and of the elements of the test. And we say that that failing was carried through into the Upper Tribunal's approach to the matter. The Upper Tribunal rejected a number of challenges to what were essentially factual matters within the purview of the First-tier Tribunal, which we haven't pursued before this court, of course. But then when it came to the test and the threshold, it's paragraph 155 of the Upper Tribunal. The Upper Tribunal said, halfway down the 155, the Secretary of State was unable to identify any passage showing that the judge had applied a test that was insufficiently demanding. The judge had Hackbin and Jarwo before him and considered his conclusion to be consistent with those cases and expressly applied paragraph 46 of Hackbin. Well, he didn't expressly apply paragraph 46 of Hackbin. He noted and said he had regard to the high threshold, but he didn't, and the Upper Tribunal didn't, in his stead, apply the elements of the test and identify what were the basic needs that weren't being met. And all that my learned friend, Mr. Delamere, could say about that was, well, the basic needs of Mr. Hackbin won't have been the same as the basic needs of AT. Well, yes, I accept that. But what were the basic needs of AT, and which of those basic needs were not being met? That's what one doesn't find. And if one even starts to embark on the process of trying to identify what the basic needs were that weren't being met, as I suggested earlier, she had housing, she had healthcare, she had money to buy food, she had and no suggestion of being unable to meet her hygiene needs. So what were these basic needs that weren't being met? That is what one just doesn't see addressed. And if one starts to try to address it, all of those needs were being met. And finally, those submissions and that essential flaw in both the First-tier Tribunal and the Upper Tribunal's approach in my submission is not addressed by Mr. Delamere pointing to a whole series of passages in witness statements before the First-tier Tribunal, most of which didn't actually find their way into the findings of fact of the First-tier Tribunal. So that sort of post hoc reconstruction really can't help. Ground 3, then. I'm sorry. In fact, it's not ground 3. It's ground 2. It's the ground 3. Sorry. It's the role of state support. The significance which local authority, in particular, support should have in the analysis. And what my learned friend submitted essentially is that it's not open, wasn't open to the Secretary of State to point to a purely theoretical remedy. And we say, well, that is perhaps the essence of the dispute between us. It is not a purely theoretical remedy. It is the statutory remedy, the primary statutory remedy which Parliament has put in place, and in respect of which there are legal and non-legal routes to enforcement. And just to give an example, if we were to put in place the sort of decision-making structure which my learned friend says is required, we get the form in, and the form has a box saying, please tell us what your local authority has provided you with. And the answer was, oh, I haven't asked them. I haven't been to the local authority. Well, what are we supposed to do then? Surely the answer is, well, you should have gone to your local authority. And
do you have that problem with your hardship applications?
Well,
we were looking at.
I've got something to say about the hardship applications in terms of the numbers which the court was provided.
Of course, do come on to that. But when we were taken to that regulation and we looked at it, and it says you fill in a form,
Yes.
you've got to provide the information that they require, and then they take into account very similar things to the things that you've identified as saying that this person is adequately provided with. So I'm just wondering whether, when applying hardship, you presumably have to ask whether they're getting Section 17 support.
Nadia, I think that's something that I will take instructions on overnight
Of course.
I haven't seen the form.
Well, I'm saying these problems arise. All I'm asking is, do these problems arise in things that the Secretary of State is already having to cope with?
Yes, absolutely.
The solicitor's shaking her head very vigorously, so I suggest you take instructions.
I shall look forward to talking it through with her after court. But if the claimant says, "Oh, I haven't been to the local authority," well, it's not a theoretical point. It is, well, you should have been to your local authority. They are the primary recourse. Well, if they said, I had been to the local authority, but they gave me a decision which is plainly wrong on its face. For example, it said, you can't have any Children Act support because you don't have any children, and I do have children. Well then, the answer to that is, well, the local authority needs to take a lawful decision under the Children Act, and that's what you should be pursuing, rather than coming to the Secretary of State as your avenue of recourse. And everything else, every other factual scenario, can be a variation on those. And it's the nature of the inquiry then, which is to be imposed upon the Secretary of State, which is different and which is particularly difficult in terms of having to judge, well, why hasn't the local authority given the appropriate support? What avenues of recourse have been tried? Is the application process too complicated? Is the complaints process too lengthy? So all these sorts of things, extremely difficult to assess. And so far as the hardship payment regime is concerned, and this will make my final point, we asked my learned friend Junior for the source of the figures that Mr. Delamere gave you. We followed the links to find that the number of people receiving hardship payments in 2021 was around 200 for the vast majority of the year. I think we'll.
Well, I think can we hold that over, because there's general. I mean, I'm not saying that you're wrong, but I just think you perhaps need a conversation between you.
I think the answer to that, mate, is that the sanctioning stopped during COVID.
Ah. That would.
There is some.
That would seem logical.
So I may be right, but for the wrong reason. But we'll look into that. Similarly,
Is that all you wanted to take us to ground 3?
yes, please. Subject to I'll come back further on the question you asked me on
Yes.
the hardship regime.
Very well. So tomorrow we've got ground 2, and anything you want to add to ground 1. So what are we talking about? Half an hour. So your obligation. If you don't mind, I think we'll still sit at 9:45, even though we're probably going to finish more rapidly because there's lordship has made himself available tomorrow at some significant professional inconvenience. I think we'd let him go as soon as we reasonably can.
Even if it's a problem.
Unless it's a problem. Is it a problem for anyone? I think everyone will have altered their lives already to get themselves here.
My lady, one matter I could ask your indulgence I forgot to mention, which is the decision in W, which is the decision of Mr. Lord Justice Bean and
yes,
which does have the common law duty of humanity, paragraph 34.
There's A, that, and B, it's a very good account of the NRPF waiver regime.
Yep.
What you'll notice from the entire report is that nowhere does the Children Act appear in argument in that case.
Very well. In that case, 9:45, please, everybody. Thank you very much.
All right.